Okay, we're going to get started again. Have y'all been able to hear okay? Is the volume okay? We have Terry Garrett with the Garrett Law Firm, and she specializes in elder care. And I'm going to let her introduce herself so she uses all the right words. And I'll have, there you go, Terry.
Okay. Well, as you now know, I'm Terry Garrett, and my associate Melanie Ibarra-Herrera and I are here. We practice as the Garrett Law Firm. I'm one of 4 board-certified elder law attorneys in our area. There are, as more of us get elderly, there are now like over 120 lawyers who say, oh yeah, I'm an elder lawyer. Well, about 20 of these are members of the National Academy of Elder Law Attorneys, and 4 of us are board certified. 2 of the 4 are really, really great. They've been doing this for 30 years, 40 years. So if you have something really, really complicated, I recommend that you don't hire me. I'd be happy to help you, but when we get really difficult cases, we call on Clyde Farrell or Marilyn Miller because they've been doing this for many decades, not just 1 or 2. I wasn't always an elder lawyer, and I wasn't always elderly. I started out studying economics and economic history, going to Wharton, working on Wall Street, doing international finance, and drafting these documents that create these investment products that we all invest in. And then I adopted a little girl, and she has more special needs than a barrel of monkeys. So I had to learn about special needs law. And then I found out, elder law, that's helping elderly people like me prepare for when they might have special needs. But with 39% of us needing nursing home care and 57% of us needing assisted living, I don't feel it's so special anymore. But what does an elder law attorney do? It varies from attorney to attorney. I'll tell you what we do. We take Medicare appeals. Many people think that you have to get more than that 20 days, which Medicare allows you, you have to make progress. No. Under GMO v. Sebelius, that is not the standard. If you need therapy to maintain or to prevent you from declining, you still get Medicare. Now, those appeals they're not that hard for us. But unfortunately, and they're just usually a telephone call appeal. The difficulty is that only 2% of people know they can appeal, but 98% of people win. And the difficulty we're all encountering now, who has Medicare Advantage? Okay, everybody else has traditional Medicare? I hate Medicare Advantage. I hate Medicare Advantage because we taxpayers pay them 105% of what we pay for traditional Medicare. And in exchange, they have these prior authorizations, and they have these algorithms. Humana and United Healthcare use NaviSign, and it has it says, well, if you have this condition, you should only be in the nursing home that many days, and then they kick you out. And so we say, appeal. And of course, they catch you because you have to appeal by noon of the next day. And it's a telephone appeal, and they love to call you back after hours or on Sunday and say, well, we need additional information. We couldn't reach them, therefore the appeal's denied. I have one phone. They can always reach me. And we always win. Because what the algorithm says isn't your experience. So that's one thing we do, is Medicare appeals. When somebody doesn't have their medical power of attorney and durable power of attorney in place, and they have a stroke or develop dementia and need someone to make medical decisions for them, someone to pay their bills. We represent people in seeking a guardianship. But I want to reassure you that if you have a good medical power of attorney and a good durable power of attorney, there are very few circumstances in which you might need a guardian. Bill spoke about Medicaid pre-planning. We do that as part of our estate planning. I say we have two kinds of clients. We have those who plan and those who run into a wall. And we can do a lot more for those who plan. What do we want to plan for? We want to plan as estate planning attorneys, not an elder law attorneys. Next slide, please. No, I'm sorry. That's okay. That's fine. Not only, what happens to your stuff when you're gone, we want to take care of you while you're here. Whoever inherits your stuff is not our client. You are our client. And as we know, those acute diseases which used to kill us quickly have now become chronic conditions. My grandfather had high blood pressure and he died at 67. In 1965, when Johnson signed the bill adding Medicare and Medicaid to the Social Security Act, that's when the average American man died. That's why we don't have a trust fund for Medicaid, because Congress said people will get Medicare at 65. A few of them will live long enough to use Medicaid, but not many, so we'll just pay it out of the general tax revenues. Well, my mom will turn 98 on June 9th, and she is in independent living. Now she needs assistance in a wheelchair, but you can see that we're living longer and everybody's using Medicaid. Among Texans, if we're among the 39% who need nursing home care, 96% of us run out of funds within 6 months. A lot can be preserved for the community spouse. Less can be preserved for the estate of the surviving spouse. So we have rising medical costs. Next slide, please. And it's wonderful that we have this unexpected longevity, with it unexpected challenges and unexpected rewards. But we have to plan for those rising medical costs at the same time. Next slide, please. We have decreasing purchasing power. Our federal deficit, a third of that federal deficit is due to COVID. We just couldn't plan for that. Nobody could. And then private equity investments, as you've read, they just increase the costs of medical care from the doctor's office to the hospital. And inflation, while it may be coming under control, we've already seen how our grocery bills have gone up, and they're not going to go back down. Next slide, please. So we must plan, and my idea for myself is that I'd rather leave money on the table than run out of money during life. We see people who run out of money. None of us want to wind up in a nursing home, but this is worse, because who's going to pay for you? Maybe your kids, if they can. Next slide, please. We also don't want to throw money away. We may not be able to have that treat that becomes, a regular. We may not be able to splurge as much, because now we have to be adults. We have to think about, what am I going to need in 20 years or 30 years? Next slide. But we should count all our resources. Don't just count what's in the bank or in the brokerage account. Think about your ability to take good care of your health, your ability to stay in community, your relationships with your friends and family. We know that all of these keep us healthier longer. Next slide, please. And we have to beware of leaky faucets. You know, there are so many high transaction costs, hidden fees, turnover costs. We're often tempted to chase some elusive high stock market return, or to buy some annuity which provides income for life, but with no inflation protection. So, you know, our Social Security is a form of annuity. It will pay us for life. But the COLA for Social Security is the Urban Consumer Price Index. It is not adjusted for the increasing medical costs we face, so that overall, and of course this varies with how much inflation we experience, in a decade, my Social Security will buy only 2/3 of what it buys today. In 2 decades, it will only buy half. We don't want to buy an annuity that does the same thing. We also don't want to buy a bridge. If we buy long-term care insurance, we don't want to buy the Texas long-term care insurance partnership policy. We don't want to buy that because it's one of these things that sounded like a great idea at the time. In my colleagues' experience, in 30 years, this has never paid off for anybody, because what the partnership policy promises is that if you buy a policy to pay $300,000 and then you've used all of that up and you go on Medicaid, it will protect $300,000 in assets. The reason it doesn't pay off is that nobody wants to go into the nursing home, so we spend that extra, quote unquote, extra $300,000 on home health care or assisted living. So we want to be careful about what we buy. We want to beware of reverse mortgages. A reverse mortgage, it may help you at home if the amount that you get, and you can only mortgage for up to 60% of the fair market value, if the amount that you get after paying for taxes, maintenance, repairs, does leave something extra, but reverse mortgages roll in hidden upfront fees, making the actual cost very high. If we want to access equity in our home, we might be better off just moving to a condo, downsizing. If we don't want to do that, we may well be better off, particularly in today's interest environment, in just postponing paying, deferring our taxes until we're gone. When the reverse mortgage, there's no hope of you actually having a reverse mortgage and leaving something in your home to your kids, because the reverse mortgage lender, when they sell the home, they sell it to themselves for less than fair market value, usually for the cost of the loan. I mean, this is what all lenders do. And there's nothing there. We should note that there are a lot of people out there with fancy initials after their names that are trying to take a bite out of our silver tsunami. You know, it's, what do the bank robbers say? That's where the money is. A lot of people call themselves financial planners. Or we recommend that if you do hire a financial planner, that you go one of two ways. That you get somebody who is both a certified financial planner, who at least has taken an exam and supposedly abides by certain ethical rules, and a registered investment advisor, because they are required to follow certain ethical rules. But those people charge 1 to 1.5% of assets under management. And a study recently published in the Wall Street Journal said that, well, this takes, over your investment lifetime, this takes half of the amount you would have earned. The other way might well be to get a fee-only planner. And Melanie, could you hand those out? We have handouts for you. And although it's not June, I thought I'd include our June newsletter to clients. And in it, we say, here are some people who are fee-only, and you go and you pay them a few $100s and you get your plan. Some of them you could go back and see again if you like. Having worked on Wall Street and done international finance for years, now that I'm looking at my brother's investments, at my investments, and at our clients, I see that there are a lot of leaky faucets out there and a lot of bridges being sold. Next, please. You probably are familiar with the idea that we should have our retirement funds in buckets. Living expenses, emergency expenses, long-term care, and I think for all of us, that's the emptiest bucket because we never expected to live this long. But the cost of long-term care, most long-term care is actually provided for by family members for free. And Age of Central Texas has a wonderful caregiver you. There's, in our area, there's something called caregiving.com. You can get more information out of the resources for older Americans and their families on our website, which we're always updating. It's very important to not be the healthy spouse who suddenly passes first. But whoever helps us, and wherever we are in our final years on earth, we want to consider how we live, how we die, and what is our true as well as our financial legacy. Our job as elder law attorneys is to keep you in charge of your own life. Next, please. Home health. Medicare, by the regulations, is supposed to pay for 28 hours a week, up to 28 hours a week of home health care. The money just isn't there. What we see is that it pays for up to 6 hours. Usually the nurse comes once a week, the therapist twice, and the certified nurse assistant 3 times to help somebody bathe. But there's more. Any veteran is eligible for 12 to 20 hours of home health care. Texas has a Medicaid home health subsidy, which for people who qualify will pay for 30 to 50 hours a week of homemaker and home health care. We have to cobble it together, but there's a lot we can do. Everybody knows about Medicare and Medicaid. There's also something called the Administration on Community Living. It's part of the Federal Department of Health and Human Services. And it funds its money. Meals on Wheels, that's through the Administration on Community Living, as are many other programs and local grants. These are accessed through your area agency on aging, in our area, the Capital Area Agency on Aging, and in the same building, the Aging and Disability Resource Center. And there are just like wonderful programs that people generally don't know about. And some of these are through a grant from St. David's. One is called Capable, and they come out and they ask you, what do you need to help you stay home? And they'll put in a ramp, they'll put in grab bars, they'll have an OT and an RN come out and talk with you about what you need to help you age in place. The Texas Medicaid home health subsidy I spoke of, it has a wait list of 2 to 4 months and then another couple of months before services start. But through these agencies, we're able to get lifespan respite care. It's short term, but it starts in 2 weeks. So if a loved one has suddenly declined, you don't want to wait 6 months. You want somebody now. Of course, staying at home is even with all of these programs, is very expensive, and we probably can't stay home forever. In fact, we have a colleague in the Valley who had a couple, they started, their nest egg when they retired was $5 million. And they had chronic conditions, they wanted home health care 24/7. They went through $5 million, and she wound up helping them apply for Medicaid. So, you know, time and chance happens to us all. Assisted living, it sounds so nice. It sounds so much nicer than a nursing home. Assisted living, to be a candidate for assisted living, you must need substantial assistance, usually hands-on, with 2 of the 6 activities of daily living. These are bathing in maybe a sponge bath, maybe a shower, dressing and grooming, using the toilet, maintaining bowel and bladder continence, getting sufficient nutrition and hydration, this could be through a JPEG, and moving from one position to another or one place to another. A lot of hospitals or assisted living like to say, well, she could shimmy over from the bed into the wheelchair. She transitioned. I said, no. I ask my clients, if your mom fell, could she get up? Fall prevention, another program available through the Capital Area Agency on Aging. In a given year, 1 out of 3 of us over 65 falls. Falls are the major cause of broken bones, guess what? And they lead all too often to long-term disability. An assisted living facility, nice looking though it may be, is basically an apartment complex with a dining hall, a beauty parlor, and then add-on services for a fee per service or as the levels rise. Levels of care rise. Oh, and they have vans, you know, to take you to dialysis, and if there's room on the van, to Walgreens. There are regulations, and in some states they're not regulated at all. Their regulations in Texas are fire department regulations. Basically, how fast can you get the people out? Fortunately, in Texas, our Texas State Long-Term Care Ombudsman does investigate complaints against assisted living facilities as well as those against nursing homes. As I mentioned, 57% of us will need assisted living. For some of us, that's all we will need. But the average time in assisted living before going to a nursing home is 2.2 years. So some of us will go straight to a nursing home, some of us will go to assisted living, and some of us will go to assisted living and then to a nursing home. Next, please. Oh, I thought I had a bigger home there. Well, in Texas, only 3% of the nursing homes meet the federally mandated number of hours of required nursing home care. Only 3% of our nursing homes are private pay only. We kind of guess they're the same 3%. If you can afford it, we recommend that you go to private pay only, because if you private pay in a nursing home which accepts Medicare and Medicaid, you are subsidizing the other people. Private pay is, in our area, is running up, it's nudging up around 300, $270 to $290 a day. Medicare, and this is why everybody wants the Medicare patients and everybody wants to kick them out before they can apply for Medicaid. Medicare nationwide averages $504 a day, Medicaid $212. One of the things I said we take Medicare appeals. We also, when the person calls and says, Mom's in rehab, I say, how many days has she been there? And if necessary, we say, come in today. We get that Medicaid appeal filed because no one can be discharged from a nursing home while a Medicaid application is pending or while an appeal is pending. All of these are, not great things to think about, but we have to be realistic. We have to be the adults in the room for ourselves. Okay, I've lost my place. I guess I'll call it a senior moment. There we go. Okay, I guess now we get to what you think an elder lawyer does, and as elder law and estate planning attorneys, we do that. We try to keep you in charge, and next slide. We do that by providing certain documents. I understand you've heard of some of these before, but not all of you have heard of them. Oh, and by the way, these first three you can get for free off of our website.
All right. As a brief introduction, my name is Melanie Ibarra-Herrera. I'm an associate at the Garrett Law Firm. I'm also a native Spanish speaker, just in case you guys have anyone who really needs some help in Spanish. Just one moment. Can everyone hear me okay? Perfect. All right, so the first document we're going to be talking about is the HIPAA Medical Information Release Form. This is a form that you can get for free on our website. A lot of doctors' offices will give it to you upon your first meeting with them. What this document does is say who the doctors can talk to when they are wanting to get an update on your care. This is particularly important in case of emergencies. If you are incapacitated or for whatever reason unable to speak to your loved ones, you want them to be able to call and say, can I have an update on how mom's doing? Can you tell me anything about dad's current condition? This person cannot make medical decisions on your behalf, so we generally recommend that you name anyone who you might want to know how you're doing. We've had people name anyone in my church prayer group can call and ask how I'm doing, because they, again, cannot make decisions on your care. They can't say, well, whatever surgery you recommend, don't do it. That's not what they're there for. They're just going to get an update on how you're doing. The other thing we list in our HIPAA medical information release form is an opportunity for you to list your Medicare policy number and state that your elder law attorney can get information on your behalf, and that is in reference to the appeals that we talked about a little earlier. If you would like us to take on an appeal and you're unable to gather your medical information so that we can take on that appeal for you, having that in your HIPAA form allows us to know exactly who we should be calling and gets them to give us the information. The next document is the medical power of attorney. And so if the HIPAA form is like your ears who can listen to information from your doctor, the medical power of attorney gives your agent the power to be your voice. This is the person who is going to be able to make medical decisions on your behalf. They should only be making them as to what they think you would want. So if daughter doesn't want mom to have the surgery, but she knows that if mom could say yes, mom would have the surgery, daughter should be saying, yes, elect for the surgery. They should only be speaking as to what you want personally, not what they would prefer. And so you have an agent, and then we always recommend 2 successor agents in case first person is unavailable or just says, you know what, this is a lot, I can't make that decision. I can't be the one to say, give mom the surgery. I'm gonna pass it on to her successor agent to make the call. And the next document is, the next document I'm gonna be talking about is the advance directive, otherwise known as your living will. And what this document does is allows you to say that if you're in a terminal condition and are expected to die within 6 months, do you want treatments to continue for as long as possible, or would you like to be allowed to die as gently as possible? The other condition it states is if you're in an irreversible condition and are expected to die without life-sustaining treatment, would you like to be kept alive for as long as possible or be allowed to die as gently as possible? Now, not everyone elects to have an advance directive, but when people do, it takes away that choice from the medical power of attorney, which can be really helpful in cases of families when they say, if I'm in this scenario and my medical power of attorney is my child, I know it's going to be really hard for them to say, let mom die as gently as possible. That's what she wants. And so this allows you to have your say without, in some people's instances, seeing it as a burden to place on their agent if they can't make that choice for themselves. And so now Terry's going to be speaking about the other documents again.
And first telling you that we've been giving these 3 documents for free on our website since the pandemic, because you have to have legal capacity to sign a document, and the only people I've met who don't have legal capacity to sign the medical power of attorney are either actively dying or their dementia is so advanced they wouldn't recognize anyone, so they don't know who to appoint anyway. But I felt really bad about giving this advance directive, this what in some states it's called a living will, when I read that article in JAMA, and I look at JAMA, the Journal of the American Medical Association, every day. And there was an article reporting on a multi-year nationwide study of these living wills, these advance directives, and the question was, does having an advance directive get you better care at the end of life? And the answer was no. So it's like, great. All these years I've been giving this to my client, it doesn't get them better care. But the article went on to say what does. And what does is frequent, or at least repeated, conversations with your family. Sometimes Melanie and I are called to the hospital when somebody's dying and there needs to be a will. For example, a will so that funds will go into a special needs trust for the other family member who was in the accident but is expected to survive, so that they can have their public means tested benefits and their inheritance. And what we see happening, not always, but often, is that the hospital social worker gathers the family members and brings in the treating physicians, and she says, well, or they say, this is what's happening. It could go this way, it could go that way, it could go the other way. You know, life and death isn't a life switch. Our health is nuanced and changing. But if you have those repeated conversations with your family members, they will understand what you'd want in this situation, and they'll be able to tell the doctor. To help you do this, we've included in your handouts a guide to difficult conversations, because we all know that the kids who say, oh, Mom, you're going to live forever, don't talk about this. And it's like, well, no, I want to talk about this because I want to live the way I want, and I want to die the way I want. So you can have an advance directive, and in some situations that might be just what you need. But have the conversations too. And write a letter and attach it to your medical power of attorney, because when you're in the hospital and your child shows up, they're going to be upset. You know, my mom is in Phoenix. If I got a call and I had to fly to Phoenix, it's like, oh my goodness, what's going on? I wouldn't have confidence that what she told, what she told me, X years ago was what she wanted. But if I have her letter, I'll know. Those are the basic documents which any estate planning attorney should give you, together with a durable power of attorney. Now, a lot of estate planning attorneys will give you something you could just download from the internet called a statutory durable power of attorney. But as elder law attorneys, we want to do better. If you don't trade commodities and options, we don't think your agent should either. So we want to take that out. We want to let your agent take your pet to the vet if you have a pet. We want to let your agent hire home health for you. We want to let your agent, if you have a revocable living trust and forgot to put something into it, to move things into that revocable living trust. We want your agent to be able to redirect your mail if you go to assisted living so that you actually get your mail. And my very favorite, let your agent pay your taxes. We also want to restrain what that agent does. This is really the most dangerous document we write because it doesn't take away your access to your funds, but it gives your agent equal access. A lot of people don't realize, so we put it in our durable powers of attorney, that the agent must report to you, must give you an accounting, and we say must account to your tax preparer, who'll need to know, to your successor agents, and in some cases to your elder law attorneys, so that if you think something's strange, you just call us and we demand an accounting. We also restrict what the agent can do so that your estate plan stays your estate plan. We say that unless you get divorced and the judge says this is the way you have to divide things, or there's a better tax result, or you need to move funds, recharacterize funds, reallocate funds in order to qualify, whether for nursing home Medicaid or for that Texas Medicaid home health subsidy, your agent can't make any changes to your bank accounts, to your brokerage accounts, to the survivor on your 401k, because we want to do as much as we can to protect you. We do go against people who have used a durable power of attorney to rob someone, but I have to tell you that the DA will take the case only if there is a car or real estate involved because they know the money is long gone. We give a couple of other documents which not every estate planning attorney does. We give a declaration of guardian case of need. Now, if you have a good medical power of attorney and a good durable power of attorney, when are you going to need a guardian? You're going to need a guardian, and we've seen these situations. If you need to be in a nursing home and you just refuse to walk over the threshold, other than you, the only person who can decide where you live is a court-appointed guardian of your person. You might need a guardian if you are giving all your money to the Nigerian prince or to Amazon. Mom and dad, we have a case where mom and dad did everything right. They named daughter as their agent of the durable power of attorney, a successor agent on their trust. In 18 months, dad had withdrawn $400,000, and he had no idea where it went. We had to get a guardian to cut off his access to his money. But you don't want just anybody serving as your guardian. So we give you a declaration of guardian in case of need. So you can say, these are the people I prefer. And you can say, this is the person I definitely don't want. And you can say, and all of our forms say this, no facility, no employee of a facility, no paid non-family caregiver. These people have a built-in conflict of interest. We don't want them. But remember, that just tells the judge whom you want. It doesn't make that person your guardian. Only a court can appoint a guardian. And should you be worried that somebody's going to try to get guardianship over you, yes, they can apply, but every guardianship application has to be accompanied by a form called a certificate of medical examination, which a doctor completes after examining you, and the court appoints an attorney to represent you because, you may not really need a guardian. We give you a declaration for mental health treatment. And a lot of people say, why? There's nothing wrong with my mental health. And there may not be. But in a nursing home, in a 6-month period, no, in a 3-month period, try again, Terry. This is a July 2014 study, also in JAMA. In a 6-month period, 1 out of 3 nursing home residents became deluded, deranged, or demented temporarily due to a medication error. If this happens to you, your agent under the medical power of attorney cannot speak. They cannot speak with regard to mental health concerns. So we say, eliminate delirium, do this 5-minute test. We want you to have a choice as to what psychoactive drugs, if any, you take, because overprescribing is rampant. We see so many people who never had a mental health diagnosis, and suddenly they're in the nursing home, and they only have one employee for every 12 patients, so it'd be a lot easier if we just zombied people out. And we let you say if you want to have shock therapy or not, and we let you make several other choices. But the important thing is that we say, before doing anything, call my doctor at this number, call my family members at these numbers, because those are the people who know what's really going on with you, that you've always been sensitive to this kind of medication, and if they'll just wait, 48 to 72 hours, it will wash out of your system and you'll be fine. So we're trying to, as I say, keep you in charge of your own life as long as you're with us. Is there something else up there? There should be one more slide, or two more. Okay, yes, two more items before we go to the next slide. Anatomical gift declaration. A lot of people think that by checking I'm an organ donor on their Texas driver's license, that they've made that gift. In fact, that only applies, because of timing, that only applies to blood and skin. So if you want to give something more to a specific or any person for a specific or any reason, we give you an anatomical gift declaration. My favorite, I have this myself. We all are concerned about dementia and Alzheimer's. There are only 100 brains donated a year. How can they do the research that's needed? So my brain, through the National Institutes of Mental Health, is going to Harvard. When we're gone, somebody has to take care of our remains or cremains, whatever they are, and so we give you an appointment for disposition of remains, which says this is what I want done and this is who I want to do it. Next slide, please. I don't seem to look in the right direction. What is your legacy? I know that people want to leave money to their children and grandchildren, but realistically, at least 39% of us are not going to. If you are in a nursing home on Medicaid, remember 39% of us will need nursing home care, and 96% of Texans run out of funds within 6 months. We can, using a transfer on death or a ladybird deed, we can always save your home in Texas, and using a transfer on death or a ladybird deed, pass it to whomever you name on your death. We can use a DMV form to pass your car. We can make that $2,000, which you're allowed to have and apply for Medicaid, be a pay-on-death account. But really, a lot of our clients die with clothes and shoes. I suspect that a lot of our clients in the assisted living facilities spend all of their money. Assisted living, from what we've seen, it runs to $6,000 to $11,000 a month in our area. And since the pandemic, the assisted living facility contracts that we've seen all require a family financial guarantee. So I think that what we gave our children is the way we raised them. And what we give all the people around us is who we are. And that our real legacy isn't financial for any of us. Our real legacy is relational and spiritual. Stanford University has come up with what some people call an ethical will. It's a template to help you write that letter, reminding people of your legacy, your true legacy. It may be, family stories and grandma's recipes, but it's really what you want to be remembered for, who you are. And that is also in your handouts. Thank you. Any questions? Yes.
Are most of these forms state-specific, or have you created a trust in other states?
That's such a great question. It's so frustrating to us because we're a mobile society. Pardon? Oh, repeat the question, thank you. Are these forms state-specific? Yes. There are 28 states which accept one another's durable powers of attorney. Texas is among that 28. Texas has its own special form of medical power of attorney. Texas will probate a will which was properly executed in another state, but trust law is state-specific, and all these other forms are state-specific too. So if you move from Nebraska to Texas, you need to have an attorney look at your trust and modify it to make it comply with the laws of Texas. But those laws can be more favorable. No. Oh, if you write a letter and attach it to your medical power of attorney, does it have to be notarized? No. Just write the letter.
What forms do you need a lawyer for? There's some forms that you don't need a lawyer for. You can just download them off of your website. But what things do you need a lawyer to be involved in?
Okay. What forms do you actually need a lawyer for? When do you need a lawyer's involvement? Some people think that lawyers just draft forms. I think that's pretty useless. I think that what we really do is consult and try to help you address your particular situation. As I said, I'm happy to give the HIPAA, the medical power of attorney, and the advance directive for free off of my website. You could download a statutory durable power of attorney from the internet, but I wouldn't advise it because it doesn't give the person all the powers they need, and it doesn't allow you to think about what restrictions you might want to place. The other forms are also state-specific. Wills, don't do your own will. Wills should be drafted by an attorney. Trusts should be drafted by an attorney. One of the benefits of having an attorney draft your will is that we put in things like because we also do special needs, any bequest to somebody who is disabled will pass to a special needs trust for their benefit. Why do you want that? Most of us have spouses of about the same age. When we die, our spouse is likely to have challenges. We want them to be able to have whatever public means tested benefits there are, including Texas Medicaid home health waiver or nursing home Medicaid, and still have their inheritance. Let's talk about this a little bit. Before the age of 65, any money going into a special needs trust is not counted for Social Security or Medicaid. After age 65, it is, and it can only go into a trust, a special needs trust run by a charity. It's counted, but through something that's called the half a loaf plan, approximately 60% of it is preserved and doesn't go to pay the nursing home. Other documents that you might want to consult with an attorney, although the attorney wouldn't necessarily prepare it for you, would be a letter of instructions regarding your trust. You could get a memorandum for personal property and heirlooms, which has to be witnessed and notarized just like a will. We had a client the other day, and she said, "My daughter and I had the greatest fun going to garage sales, and we bought this bowl for 25 cents, and I want to leave that to her." And so we said, "Yeah, sure, fill it out." So the real reason you see an attorney, unless you have complex, we none of us think we have complex plans, right? But the law keeps changing and the law can be complex, is for the consulting to really plan for your life while you're alive and for whatever remains when you're gone. Yes? Oh, I'm glad you mentioned that. Don't do that. Okay, he said, this gentleman said that when he was working with a lawyer on behalf of his mother, there was a durable power of attorney. And it's true, the statutory form says that it can be effective immediately or effective on your disability or incapacity. And the one that is only effective on your disability or incapacity is called a springing power of attorney. Now, we have a gentleman in our building who uses a wheelchair. He is disabled. Does he have to, because he's disabled, does he have to wait? Did he have to wait until he was in the car accident and became disabled to have somebody help him pay the bills? What about when he was in the hospital before he used the durable power of attorney, or before he used the wheelchair? That's no good. The other problem, and I hate this language, is that it says disabled or incapacitated. Incapacitated is a decision by a court that you need a guardian. So if the durable power of attorney springs into effect when you are incapacitated, that's no good because you need a guardian, not an agent under a durable power of attorney. So we find very few lawyers, I think we've had 3, maybe 4 times when a doctor has been willing to sign saying, yeah, this durable power of attorney should come into effect. The other reason, besides the crummy old language, the other reason to make your durable power of attorney effective now is, if somebody's going to behave in ways that you find rather untoward, you want to know it so you can change your agent. You don't want to wait until you are not able to function fully and they're just, then they start robbing you blind. You want to really have control. And remember, a durable power of attorney doesn't give them control. It gives them equal access. They're supposed to report to you. They're supposed to provide an accounting. If you find they're not doing a good job, you might want to name somebody else.
Is there any way to protect someone, and this is a very sad commentary on our society right now, but we have family members who can't be trusted. And we have older family members who are very loving and kind and sometimes have memory problems. And they are so easily taken advantage of.
Yes.
So what can we have in place to protect them?
Well, let me tell you a story first. We have a case right now where Dad is 94 with vascular dementia. He has 6 rental homes, and he has $150,000 in his brokerage account. He wants to stay home at $23,000 a month. Little sister, 67, comes to visit him every other week, and he loves her visiting, and she loves leaving with a $10,000 check. That's when we have to go for guardianship. But except if it's necessary to get a guardian to save your life, it can take 3 months to get a hearing. $10,000 every other week for 3 months, how much is he going to have left? So that's why we say those durable powers of attorney are the most dangerous things we draft. We recommend, so most people don't do this, we recommend that you have 2. One is a durable power of attorney for a little bank account that has your daily expenses. The other is a durable power of attorney with co-agents who must act jointly for selling your house or any larger transactions. Now, the good thing is that since October 2017, the banks have had to file suspicious activity reports. But if somebody just comes in with a durable power of attorney and they're the only person, it doesn't look suspicious. So consider, 2 durable powers of attorney. Okay, they just have power over different things. One person is going to pay your bills. And one is one with co-agents who must act jointly is going to do the big things like sell your house. But we still want to build in those protections that they can't change. They can't monkey with your, with your pay on death, transfer on death, or designated beneficiary designations. One of the things one of the questions that I haven't answered in the questions that we got by email was, what happens if the person closest to you is not your spouse? Use names. Use names. Don't say my spouse. Use names. Because that person can then do everything your spouse could do. Except for one thing, and that is your 401k. 401ks are under ERISA, and they have, which is a federal law, Employee Retirement Income Security Act. And they automatically pass to your spouse unless during the marriage the spouse writes a letter to the plan administrator and says, I don't want this. And then other people can be designated. And of course, if you write that letter, I would advise sending it certified mail, return receipt requested, and keeping a copy because the plan administrator might lose it. Yes.
Can you update a living will, a living trust?
Okay. Those are 2 different things, a living will and a living trust. The living will is the advance directive to physicians and surrogates saying what I want in 2 circumstances. And that you just need a new document. A living trust, a lot of people have revocable living trusts. Okay. Having a will in Texas, okay, I'm going to go right back. Because you mentioned trusts, I'm going to mention trusts and wills. In Texas, it is cheaper for a married couple to have a trust-based package with a revocable living trust than to have 2 wills and probate 2 wills if everything makes it into the trust. If it doesn't, we have to probate at least one of the wills anyway. Most of our clients do not want to pay that money up front. They prefer, I'm going to pay for the wills, and when I die, my kids will pay for the probate, which isn't that expensive in Texas, and it only takes us a month to get into court. But the revocable living trust, you can update, but you have to work with an attorney, there's your question again, and make first amended trust, second amended trust, whatever you want to do. We always recommend revocable living trusts when there is a second marriage, because then we can separate out for his children and for her children and not have squabbles late in life when one of the parents becomes ill.
But you can revise.
Yes, we do it all the time. How much does it cost to probate a will in Texas? There are two answers to that. And in both cases, the will must, and it varies, I'm sure it's much more in Dallas and Houston. If a will is properly drafted, signed, and witnessed, and attaches a properly drafted, signed, witnessed, and notarized self-proving affidavit, then you have 2 choices. If the person did not use Medicaid and has no debts not secured by real property, by real estate, you can probate in Texas as what's called a muniment of title. It's an old word meaning defense of title. And it saves you $1,000. You go into the hearing, your attorney gets a certified copy of the will and of the order admitting the will to probate as a minimum of title, records them in the deed records, and you're done. The other way, a straight probate, you do have to open administration, notify potential creditors, and submit an inventory to the court. So our fees, and correct me if I'm wrong, for the minimum of title, we now ask for $2,750 and another $600 to be deposited in the client trust account to cover the court filing fees and other out-of-pocket expenses, and if it doesn't come to $600, we refund what's left. But we ask for a probate with an estate administration, which obviously requires more work by the executor and by us. We charge $3,750 and ask for $850 to go into the client trust account, again refunding whatever is left over when we finish. Most of our clients are done within 4 months. The minimum of title, they're done that day.
Is that set by state law or?
Yeah, no, it's not set by state law. In some states it is, and this is where revocable living trusts got their start, is that in Florida and California, the probate attorney, and in California, the executor, gets a percentage of the estate by law. So everybody said, no, I don't want a probate. I want to have a revocable living trust. But in Texas, we don't have that. We do have rates, hourly rates set by the local court. My hourly rate is set by, Judge Prashner told me I was charging too little. And he raised my rate to $325 an hour and Melanie's to $225 an hour, and our paralegals to $150. But we try to flat fee as much as possible because it's better for everybody if we just know, okay, this is it, and it's certainly better for the client because they know that's all it's going to be.
Any other questions?
Yes. Yes. Sorry, it's because now you had to probate his will. A lot of people, this is another point that a lot of people get confused on. We're a community property state. That doesn't mean that the home goes to the surviving spouse automatically. That means that each member of the marital community has a 50% interest in the home, and so you had to probate your husband's estate to get his 50% interest into you. But then when you pass, your 100% interest has to go somewhere. You could pass it free of probate and free of Medicaid estate recovery using a transfer on death or ladybird deed, or if you have a lot of other things that are not passing through pay on death, transfer on death, designated beneficiary, I guess your kids will have to probate your will.
Anything else? One more?
Yes, please. Okay, there's do you need and do you want? Do you need, and I think, do we have, Melanie, would you look and see if, do I need a revocable living trust, if that memo is in our handout? People who need a revocable living trust are those who, as I mentioned, are in a second marriage because we want to separate things out now and not have the kids fighting when one of the parents becomes ill. You know, you're not going to use my mom's money to pay for your dad's illness. Okay. And they do fight about that. And then people who have out-of-state real property need a revocable living trust because you don't want to have to probate in another state. Why pay for 2 probates? People who have a love child or have very unequal distributions, you know, I like Johnny more than Susie, probably should have a revocable living trust because unless there is a court case, you know, involving, say, the trustee not doing what they're supposed to do, those are always private documents. There are 2 other instances in which we recommend a revocable living trust. The federal estate tax exemption is expected to, it's now at 13.61 million, so if any of you married couples have over $27 million, you might want to trust. And but it's expected to fall to 5 million adjusted for inflation in 2026. So if you're bumping up against that, or think you might by the time you pass, you might want to have a revocable living trust in order to avoid the federal estate tax exemption. The other is a situation which does arise but may not arise in your case. If we have a couple, right now, the spousal protected resource amount for the spouse who's not applying for Medicaid is $154,114. If we ordinarily don't put the house in the trust in Texas because it's counted if we do, but if we want to protect more money, we put the house in the trust, and then when the person applies for Medicaid, we take the house out of the trust, making it uncountable, and then increase the amount of cash assets which can be retained by the spouse who's not applying for Medicaid. So there are instances, if you're confident that you're going to get everything in the trust, it's cheaper to do a revocable living trust than 2 wills and 2 probates. But if you don't, it doesn't save you any money.
Well, we want to thank Terry today. Thank you so much for being with us and spending your Saturday morning with us. And I'm sure Terry will be around for a little bit if you have any other questions. And I want to thank all of y'all for being here. Thank you so much for coming out on such a beautiful day after having a week of some rain. But in the next workshop will be July 13th, and it'll be on community resources. And it'll have the Area Agency on Aging will be here to talk about all the programs they have. And then we'll have some local businesses that provide services to help us, stay in our homes as long as we can, or if you need Terry and, Melanie for being with us today. We really appreciate it. Thank you. And we'll see you later.